I'm ready to be a GAL. Give me some cases. Well, clearly half of you have had enough of me, and the other half of you probably have too. You're just more polite. So, thanks. The first child abuse case in the United States was Mary M., and it was brought under animal cruelty laws because we did not have child abuse laws on the books at the time, and this was in the late 1800s. So her father had to be basically prosecuted under animal cruelty laws rather than any kind of child protection laws. And just as the gangster anthropologist said, we still have the problem of being a very Puritan society when it comes to how we view our children. It is still a society of children should be seen and not heard. And best interest, the involvement of best interest, really is not good either in the United States. So although it's what guides your practice, it's your client, which I didn't really get that till yesterday. It is not an ideal that really came about because we cared about our youth in this country. And it really was not a benevolent concept. It really was about control and power in the adult. And this was seen throughout our history, starting with the move from an agrarian society where children were considered just small adults and worked from the time they could walk in the fields, on the farms. And as the country moved towards more industrialization in the early 1800s, and people moved into the cities and got jobs in factories and in the cities, what happened were a lot of people came from other countries, immigrants, to have jobs in the cities here. And many immigrant children were the children that ended up on the streets selling newspapers, candy, matches. And the Victorian people of that age, the considered child savers, decided that those immigrant youth shouldn't be doing that, but they should be sent to reform schools where they could be given better opportunities, and those reform schools should be back in the bucolic agrarian areas where it was so much more beautiful, and they could replicate the way life was in the agrarian society, which was very difficult and was not bucolic. And those kids ended up being sent into indentured servitude into the factories in the cities. So even though the child saver movement seems to have a lot of pull with sociologists, anthropologists, as a very benevolent movement, it really, in many senses, wasn't. I mean, Jane Addams did come out of that movement and started the first juvenile court in Chicago in 1899. But really, overall, it was about giving opportunity to non-minority youth, was what the child savers were about. Also, out of that belief came the orphan trains before foster care. And the orphan trains were from New York, from the Child Welfare Association, where they took kids who they said were orphans, but now we know many of them weren't, they were just poor, and put them on trains to go to the Midwest, where they were put on platforms in Nebraska, Kansas, Minnesota, and farmers would come and say, yeah, I want that one, and they were put into the fields. And basically, many worked to death. And all their paperwork was destroyed, so they no longer knew who they were or where they came from. And the, one of the youth here, Victoria, wrote her college thesis on the orphan trains and was telling me about it. And it's really great to see somebody so young who's connected into the historical aspect of how we've treated youth and where best interest came from. And then, of course, as things developed and children were in the labor market and in the factories because their little hands were so nimble and they could get into little parts and all those things, and they were really worked to death in factories. And several states tried to pass child labor laws, and every time they tried, those laws were found to be unconstitutional by the US Supreme Court because under the 10th Amendment, they interfered with the states' rights to regulate labor in their states. And also, it was because they needed children in the labor market at that time. But as things changed and adults, this was during like World War I, and when people were in war, and so the jobs were available, and we needed youth to do those jobs. When people came back from war and when the jobs started paying more, children weren't wanted in the labor market because adults wanted those jobs. So in 1937, when the Fair Labor Standards Act was passed by the US Congress, it was upheld because they wanted kids out of the labor market by that time. So none of this was done because we really, as a country, cared about our children. It was because there was a purpose behind those beliefs in best interest. The best interest was either they should be in the labor market or they shouldn't be in the labor market, or we need compulsory education or we don't need compulsory education. It really wasn't in their best interest like you all consider best interest. It doesn't come from a real holistic, caring ideal. And when the Fair Labor Standards Act did pass, one of the only group of children excluded under its protections were newspaper carriers, where at the time when immigrant kids were the newspaper carriers, they were taken off the streets and put in reform schools. When then, after the Fair Labor Standards Act, they were called independent contractors, children, so that the newspapers didn't have to give them the union benefits they had to give everybody else that worked for the New York Times. So this is our history of caring about children, and where the best interest comes from. Best interest comes from, as you know, England, parens patriae, which really was about stepping in for a parent in issues of probate, inheritance, when there was no parent. So I just think it's interesting to look at where it comes from. And also, in your materials, I provided copies of the Convention of the Rights of a Child and some information about that, because we are the only country with a recognized government that hasn't ratified the UN Convention of the Rights of a Child. The United States and Somalia stand alone in this world, and Somalia doesn't have a recognized government. And so what's in the UN Convention of the Rights of a Child, it was passed in 1989, it's a human rights treaty. And human rights treaty law, or just international treaty law, if the treaty is ratified by the majority of the world, it should be enforced by everyone. It's kind of that kind of treaty law. So we do cite it in our briefs where we're talking about taking children out of the adult system, when we were talking about getting rid of the death penalty before Roper and Graham with juvenile life without parole. All those things are in the Convention of the Rights of a Child. You can't do them. You can't do them. And the countries that have ratified it, some do it, but then you get to use the treaty to challenge it. And there is a woman in Pretoria, South Africa, who runs a children's clinic at this law school named Anne Skelton, S-K-E-L-L-T-O-N, who used that treaty in Pretoria to get children out of adult prisons. We have children in adult prisons here. We do that, and it is not allowed under the Convention of the Rights of a Child. Article 12 in the Convention of the Rights of a Child talks about giving youth voice. And it's a beautiful article that nobody really understood until 2009, when they did a lengthy commentary about what that means. And that is in your materials too. And I'll just briefly read you a couple of things. Article 12 of the Convention establishes the right of every child to freely express her or his views in all matters affecting her or him, and the subsequent right for those views to be given due weight according to the child's age and maturity. It manifests that the child holds rights which have an influence on her or his life, and not only rights derived from her or his vulnerability or dependency on adults. The Convention recognizes the child as a subject of individual rights, and the nearly universal ratification of this international instrument, except us, by states parties emphasizes this status of the child, which is clearly expressed in Article 12. State parties, which includes courts, governments, all of those things, shall assure the right to be heard to every child capable of forming his or her own views. That's not about competency. This phrase should not be seen as a limitation, but rather as an obligation for states parties to assess the capacity of the child to form an autonomous opinion to the greatest extent possible. This means that states parties cannot begin with the assumption that a child is incapable of expressing his or her own views. On the contrary, states parties should presume that a child has the capacity to form her or his own views and recognize that she or he has the right to express them. It is not up to the child to first prove his or her capacity. That's incredible power given to youth. And as I said, every country in the world agrees but us. And when Israel, a couple years ago, realized they were the only country other than the United States that still had youth serving life without parole sentences, they stopped and re-sentenced the 14 children in that country, not the thousands like we have, but the 14 that were serving life without parole at that time. And I bring this document up because it seems that the heart of this conference, not seems, it is, about giving the youth a voice. And we have to figure out, what does it mean? I listened to all the speakers, and everybody truly said it, but we never really talked about what it means. And clearly, you GALs are doing things right, because all those lovely things that kept coming up on the screen and on the tables were comments by youth you represent who say, yeah, they listen to me. It goes beyond that. Listening to them is a start, but they have to have the opportunity to be heard in court, in assessments, in treatment, in everything, as it says, that affects their life. And so how do we do that? I mean, we looked at, I see that they feel heard by you all, but then so few of them responded on that survey for the evaluation of your program of OCR. It seems that if they truly were being heard in every important aspect of their life, or in any thing that affected them, they would have responded in droves to that survey and talked about, I was heard by this judge, I was heard by this caseworker, I wasn't ever heard by my DHS worker, I'm not heard by my parents, I'm not heard by my therapist, they listen to my parents. That would have been the commentary. They would have felt empowered to talk if we truly were giving them the voice that is contemplated in the Convention of the Rights of the Child. Also, the speaker who talked about medication, she talked about how she has 3-year-olds and 4-year-olds in her office that are great communicators. They tell her what's going on. She gets it. She listens. That 3- and 4-year-old could probably tell the court what's going on. They have to have that opportunity. As the convention says, you start with the presumption that they do have the capacity to express themselves and have a voice. Let's start with that presumption. And I know there was a lot of talk about, well, if they're 15, and I know there must be in Colorado, if you're 15, you have, and I do know, the ability to consent to certain things. But that's just about certain things. It's not about how you feel about things that are affecting you in your case, ongoing. And that's where we have to give them the opportunity to be heard in every aspect of their case, because every aspect of their case affects them. And so we really have to talk about, how do we do that? How do we really go about doing that. And I'm trying to think of other areas where I've seen this kind of organizing done successfully. I mean, I'd like to see a union, the foster child union, with organizations in every state, or starting just here in every jurisdiction, where they, you know, have representatives of their union, a president, a director, that go, you know, conferences that are all only about them and how to express their voice and how to be heard. I know in Washington State, there are Girl Scout troops solely for girls whose mothers are in prison. And what's great about these common ground kinds of organizations is there's no shame to get through in your group because you all have a common bond. You all have a common experience. They all have mothers in prison. And so everything they do is easier for them because they don't have to first talk about how they're different and how it makes them feel because they all have a common bond. And it is so successful. Everything they do doesn't have to do with being a daughter of a mother in prison. It's just everything they get to do is much easier to do because you don't have that difference between members. And so I'm thinking about that and I'm contemplating how could we do this with foster care youth. And I know that Andrea works at the United Way because I talked to her yesterday when I got here, and she works with foster youth in transition. You know, she may not want to take on another big thing like this, but she may be one who you can really talk to and say, how do you think we could do something like this? How could we do a pilot foster care youth union, or whatever you want to call it, in this district? You know, I think there's funding out there that would be available because it would be so innovative and useful. And it seems like people are looking for ways to support foster care youth that is different, that does give them something that is different than what they have. You know, something new, something in a way to give them the voice that's contemplated, a voice in every aspect of their life. And I thought, you know, maybe it could be something like that, a troop, a union, something that's powerful. And then they have multiple people who can work on how they want to be heard. Maybe they want to go to the next Colorado Judicial Conference as a group and tell those judges how their decisions impact them. And yes, they're lawyers, as I saw in this, just this little test. You know, lawyers are supposed to give the child's opinion in every aspect, in every case, in every hearing. I would like the child to give their opinion. And maybe there are times when the GAL says, my client would like to tell the court. But that should be the common experience, not something that is rare or unusual. And, you know, a judge may say, well, I don't want these young kids speaking in court all the time. Why not? I mean, we have to challenge those existing institutionalized behaviors in court that are basically still children should be seen and not heard. And if the most they're going to be heard is just through their lawyer and that satisfies them, that's okay. And because that's their choice. But if they say, I want to talk, and the lawyer says, you know, you can't, this judge doesn't really want to hear kids, that's got to change. And usually we experience change through grassroots organizing. And I talk like this because I come from being raised in the United Farm Workers Union. My mother was one of the organizers, original organizers for the United Farm Workers Union in Colorado. And I was raised on picket lines, where I was always telling people in front of Safeways and liquor stores, don't buy grapes, don't buy lettuce, don't buy non-union this or gala wine. And I was, you know, 8 years old, and they would look at me and get really mad, people who were crossing the picket line, and say, get a job. And I'd say, I'm 8. And so I think, you know, that experience for me is really what propelled me into going into poverty law. I mean, I didn't always want to do juvenile law, but I always wanted to do poverty law. I always wanted to fight the system. And there was a law review article done a few years ago on burnout, public defender burnout, where the writer Abby Smith from Georgetown interviewed a lot of us who had been public defenders for over 20 years, and how did we stay in it when so many of these young law students were, I want to be a public defender, I always wanted to be a public defender, I can't wait, and after 2 years they've burned out and they're gone. And she said, Simmie, what keeps you in it? And I said, outrage. I love it. I said, I wake up every day and I'm outraged at the government, at the police, at the way my clients are treated. And if I ever didn't do this work, I would feel that I was compromising and that I was acquiescing to the powers that be. And that would be the worst feeling I could ever have. If I didn't feel that every day I was fighting, I don't know what I would do. If I wasn't outraged all the time, I don't know how that would feel. But I don't know what I'm going to do when I'm retired. Who knows? But that's what keeps me going still. And so I like to try to figure out ways to change things and how we can get what we need to do it. That's how I created Team Child in 1995. I was so tired of seeing my juvenile clients go to court on probation violations, and they were 13, and a judge would say, okay, well, you didn't get that psychological I ordered, and I felt like the person on the picket line. I'm 12. I'm 13. How am I supposed to do that? And you didn't go to school, so you're going to go to detention. And I was so angry, I kept thinking, well, how can we hold these systems accountable to my young clients, these civil systems, the school system, the welfare system, the public health system, the mental health system, the housing system? How can I hold all of those civil systems accountable in criminal court, juvenile court? And that's why I created Team Child. I wanted to ensure that when a client came into the juvenile defender system, that all of the issues that were there, that were encouraging them to offend, were peeled away and addressed while they were in the system, so we could put them out back in their community better than when they came in. And so we blended, my dream was to blend the best of the civil system and the best of the criminal system to create the holistic model of juvenile representation. And that's really how the holistic model of juvenile criminal representation began here in the United States, was in my division in Seattle with Team Child. And it was funded through the Justice Department that gives money to every state every year. Maybe during the sequestration we don't have it, I don't know. But every state has a SAG group that gets the federal juvenile justice money and then sends out RFPs for projects, pilot projects that address, it's very broad, delinquency, abuse and neglect, different kinds of things. So you really can write the RFP in a way that is very inclusive of their, the things that they want to address. It's not that difficult. Not that I ever want to write another grant proposal. That was my one brainchild in my lifetime. But that's something we can think about doing to help fund and create a foster care, youth and foster care union. And think about how we would write that grant and get that money as a pilot project in a district or in an area, so we really can start going out and recruiting foster care youth into their own union with their own voice that addresses the issues that they want addressed in their lives. Whether it be, I'm tired of judges just assuming that we don't know what's going on, or I'm tired of judges thinking because we're under 12 we don't know what's going on or have a say in our lives. And just so that you can put yourselves out there through media, through videos, through leaflets, through talks, through all kinds of things, so that you do start as a group, because there's safety in numbers. What you can, we know what you won't do by yourselves, you'll do with your peers. We know that. So why not? Why not create your own powerful group of foster care youth to ensure that you have a voice? Because although your GALs may do a pretty good job, it really is you who are going to have to get in there and fight with them. And there is nothing more rewarding or fun than a good fight. A good philosophical, a good fight about rights. Because you have rights as a child. As much as people want to say, you cannot, and you might say, Simmie, you are schizophrenic. You were just telling us yesterday morning that they aren't good decision makers, that they are wild, that they are reckless. But remember, I did say that in organized situations, they are great decision makers. And that's why we give them some leeway in making decisions about their lives. Not enough leeway. Not enough leeway when it comes to their decisions in their foster care lives. And that's something we really have to look at. They are good decision makers in many ways when they have adults there helping them. Informed adults who help them make informed decisions. I'm not talking about police officers who are interrogating them. That's not what I'm talking about. I'm talking about people who are on the same plane, who are there to ensure that when they want to talk, they get to talk, and that they are prepared because you have helped prepare them, and that they can say what they want to say. And so these are just things I've thought about listening to the speakers, listening to GALs. And I know yesterday when that panel was up, I think it was Sherry who said, well, what about the youth voice in this land decision? And they were like, oh yeah, that's my default, is that they hold the right. But somebody said, oh no, it's the parents' right. It's like, you know what? We're talking about inalienable rights of youth. They have them. And again, being the only country that hasn't ratified the Convention of the Rights of a Child, that might be something you want to take on as foster care youth, because that gives you a full voice in any aspect, every aspect that affects you as a youth. And I'm going to end with just a story about going to Lithuania. It's not a fairy tale. Many, many years ago in Lithuania. In 2000, I went to Lithuania with a Simmie project. And Simmie is part of the ABA. It's the Central Eastern European Legal Institute. And what it does, or it did, was send lawyers to developing Eastern European countries who were trying to develop democracies from communism, totalitarianism, different other kinds of government. And once they have established a democracy through usually revolution, Simmie would go in and for 2 years do conferences with them. It was usually with prosecutors and police to address corruption in the new government and the changeover from the old government. And so Simmie had been in Lithuania for 2 years, and they told the prosecutors and judges there that were part of the project, you have one conference left and then we're done. And what do you want this conference on? And they overwhelmingly said juvenile justice. We want to redo our juvenile justice system. And so they rounded up a prosecutor, a public defender, a judge, a diversion person, and a service provider, a substance abuse service provider, to go over there and do presentations, and I was the public defender. So we spent several days in Lithuania before we did our presentation, and I was looking at, talking to kids in the detention center, talking to people. We had translators. It was very interesting. And then it came time for our presentations, and the prosecutor and judge went before I did, and the prosecutor got up there and said, boy, you have a great opportunity here. You can do what we've done in the United States by and large now, by 2000. You can just keep the good kids in the juvenile justice system and put all the bad ones in the adult system. And in fact, you can do it automatically. You prosecutors can have all the power like we do to just look at a case, look at the crime, and charge it as a serious crime so the kid goes automatically to the adult system. So that in the juvenile system, all you have are good kids. And I thought, holy crap. And while we were talking on the stage, all the audience, and there were about 200 prosecutors and judges, no defense attorneys, had earphones on. It was simultaneous translation. So and when they were talking, we had the earphones on. So when the guy said that, all of a sudden there was this kind of, sounded like a wave, this din of noise. They were just talking to each other in their language, Lithuanian. I thought, wow, I wonder if they're really excited about this. And because the prosecutor said, we do it at age 15. We put them automatically in the adult system. And somebody said, but a 15-year-old is a child. And they said it in Lithuanian. We got the translation. And he's like, no, no, they've made adult choices. When they commit serious crimes, they've made adult choices. And they were like, well, if they're committing a crime with an adult and they're 15, would you still put them in the, oh, yes, they go right there with that adult, blah, 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 blah. And so then it was my turn, and I get up there and I say, well, I do have a prepared presentation, but I have to tell you first, don't do anything he said. And this is why. I said, I have spent several days traveling through your country, talking to people. And I have seen and listened to stories about your revolution and your fight for democracy. The KGB office in downtown Vilnius, where we were, is the appellate court now and a genocide museum. I know how you have changed and how you care about justice. And I know the last voice you want to silence is the voice of a child. And they all stood up and clapped. It went crazy. And then I talked about doing holistic representation involving social workers on every case, having a lawyer, a social worker, interdisciplinary teams, so that you get to the root of the matter, the cause, not the symptoms. And you really do what you need to do to ensure that that child is getting what they need before you put them out of the system, out of the court system. They loved it. They loved it. In fact, the head prosecutor, this very small man, older man who had 2 fake plastic hands, which he must have gotten during some revolution in his country, came up to me and kind of tapped me and said, that was beautiful. And so I thought, wow, at least in Lithuania they appreciate this. I had to come all the way to Lithuania, where the University of Lithuania in Vilnius is the oldest university in Eastern Europe, and the t-shirts there, this is just a really great side, the t-shirts there say, graduating class of 1589. I mean, it's just so much history and trauma in that country, and revolution, and back and forth, and all of that, and they still care about the voice of a child. And this was before, and this was, I don't know if they had ratified the Convention of the Rights of a Child by then. They have now. But there was also a judge from Austria on our team, and she single-handedly had made the entire juvenile justice system in Austria a restorative justice system, a truly restorative justice system, and got buy-in from business and everybody because she was able to convince them that you will have a lower crime rate if you do restorative justice, if the offender and the victim truly know and understand each other and see each other as integral parts of their communities, not people that are to be pitted against each other in their best interest analysis. So we know that developing countries care about the voice of children. And although many countries have child soldiers and things like that, and the problems are still huge, those countries, though, all have at least one Ann Skelton or an NGO, non-government organization, that can use the convention to change what's happening in their countries because they've ratified it. That's the benefit of ratification. The United States kind of says, well, a lot of countries still have these problems and they've ratified it, so that's kind of disingenuous. We at least admit that we do all these bad things, so why ratify it? And it's like, because they can use it. People can use it. People of change can use it to challenge the way youth are treated if it violates the Convention of the Rights of a Child. So in many of the briefs that we filed to challenge the constitutionality of trying kids as adults, to challenge the constitutionality of life without parole, we do cite human rights law because we think youth have human rights. And we always cite international law. And the importance of relying on it, even though we're the only country that hasn't ratified it. And the US Supreme Court in Roper and Graham and Miller did talk about the evolving standards of decency in this country and the world as a reason to stop the death penalty as applied to youth and life without parole as applied to youth as a mandatory sentence. And finally, in the Supreme Court case of JDB, Sotomayor wrote a brilliant, beautiful, beautiful decision. She created, which I have tried to create in my representation for many years, the reasonable child standard as a way of evaluating the culpability and beliefs of youth in the juvenile and criminal justice system. And what I mean by that is, she said, you have to look at the age, the education, the experience of every child to determine if they would know in an interrogating situation, would they know that they are free to walk away from police officers. That was a first. Because the reasonable person standard that's used in criminal law is an adult standard of maturity. The reasonable child standard considers everything we know about youth and that individual youth. And that's what we have to do. We have to start changing every piece of our system to be youth developmentally appropriate. And I know we've thrown those terms around a lot in all the services, but what it means is to change the way you do things in a big way, in the way you are giving information to a court and how you're asking the court to evaluate situations involving youth. So I think it's more than a youth voice, it's giving youth its own power and chair in everything we do and making it different than an adult, but making it powerful for that youth to be heard. And so I hope this is helpful. I hope that I know that the last voice you want to silence is the voice of youth. So we really do have to figure out creative ways to ensure that happens in everything that affects their life. As if we have ratified, as a group, we have ratified the Convention of the Rights of a Child. And I think we really should read it, and I put several materials in your online materials about it. Share it with your clients, talk to them about it, give them that opportunity, and tell them you have important rights that I can't represent without you telling me exactly what you want and what you want to say. And I think we'll hear more youth talking in court. It might take more time, it might make judges mad, but it might be exactly what our clients need to be able next time to give you full participation in your survey of your model offices and your regular OCR GALs. So I hope something comes out of this conference beyond, I mean, a lot is coming out of it for me, but I meant in supporting something different to give youth the power that we want them to have and we say we want them to have, and the voice we want them to have. And I really hope Andrea really helps you all do that. Something like Peace Jam, all those different kinds of things are all about the youth voice. So investigate, question, think about it. Do some grant writing, talk to your SAGs, and I'm happy to help in any way, brainstorming, anything. Give me a call. I hope something great happens. I think it will. Thank you very much.